Welcome to the Court of Appeals. I'm Valerie Zachary. I'll be your presiding judge today. To my right is Judge April Wood. To my left is Judge Jefferson Griffin. Assisting us today are Senior Deputy Clerk Eddie Sanders and Officer Richard Remillard. We have two cases on the calendar this afternoon. The first is TAC Stafford versus Town of Mooresville. Let's begin. Each of you have 30 minutes for your argument. Counsel, you may approach the lectern. Would you like to reserve time for a rebuttal?
I would, Your Honor, 5 minutes.
Okay. You may proceed.
Good afternoon, and may it please the court. Stephen Bader from Cranfield, Sumner, and Raleigh, here on behalf of the town of Mooresville. The issue in this case is whether Mooresville can condition approval of a 200-acre, 470-unit subdivision on the developer making certain road improvements that are going to be necessary to account for the increase in traffic. Now, the trial court determined that Mooresville lacked that statutory authority, and that decision rested on this court's opinion in Buckland versus Har River. The Buckland decision is factually distinct. It involved different arguments, different legal issues, and it doesn't control. The enabling statute that Mooresville operated under expressly confers or necessarily implies Mooresville's authority to act. And ultimately, the trial court's decision should be reversed. Now, before I dive into Buckland, I just want to take a step back and talk about the legal framework that Mooresville was operating under in this case. The former statute, enabling statute issue 160A-372(a) includes 4 different provisions that provide authority for a town to act in regulating subdivisions. And the last provision is what's at issue here. We've referred to it in the briefing, just for simplicity's sake, as the traffic provision. And that provision provides that a subdivision control ordinance may provide for the distribution of population and traffic in order to avoid congestion and overcrowding and to create conditions that substantially promote public safety, health, and welfare. Now, the town of Mooresville enacted Ordinance 111 consistent with that statutory authority. And what that ordinance says is that if a development is going to have an impact on traffic, and traffic in and around the proposed subdivision, a traffic impact analysis is going to be conducted, really to figure out how that's going to impact infrastructure, traffic, crowding, all the issues that are inherent to development.
And it's your contention that that allows you to require off-site improvements?
Well, yes. I mean, that ordinance allows that, correct, yes.
Even miles away from the development?
Yes, yes. And when we look at what that ordinance contemplates with respect to a TIA, or a traffic impact analysis, it specifically refers to the guidelines that really speak to how the TIAs are conducted, what they look for, that type of a thing. And within those guidelines, they talk about mitigation and different mitigation measures that may be required in order to achieve the goals of the TIA.
Well, I'm just asking this because I'm curious. I think I recall reading in one of the briefs that the TIA wasn't shared with the plaintiff. What was the basis for that?
And I apologize, Judge Zachary. I'm not certain I'm prepared to answer that question. I guess I don't necessarily recall that in the record, although I don't dispute that it may be there. The only thing I would add is that ultimately TAC Stafford did agree to the MMA, and in fact 2 MMAs, so that would at least indicate to me that they had an understanding of what was expected of them and in fact agreed to it. If I'm missing something, I'm sorry I can't be more helpful, but I just don't recall.
No, that's fine. Thank you.
In any event, looking at the Buckland case, You know, Buckland involved a fairly small development, 11 lots, over 7.6 acres. And what the town of Har River said in that case to that developer is, if you want this development approved, then you need to do paving, curb, and gutter to 2 different roadways that abutted the subdivision. And the developer ultimately litigated that, obtained a writ of mandamus, at least on appeal, and the only argument that the town of Har River made was that a separate provision of this enabling statute allowed it to withhold that development approval, and that was what we've referred to as the within provision. And the within provision talks about the ability of a town to really condition approval on what they refer to as conditions within the particular subdivision. And so this court, when presented with that argument, really didn't have any trouble saying that the term within, by definition, does not encompass roads that would be outside of the subdivision. That is not the argument advanced here, and that's not the manner in which Mooresville acted. I mean, Mooresville was deliberate in undertaking this TIA in response to a fairly large development, and ultimately agreeing to an MMA with the developer that accounted for the various side effects of this type of development. So we would contend that Buckland just simply doesn't control. It's certainly good law. It's just not, it doesn't analyze the relevant portion of the statute at issue here, nor is it responsive to the arguments of the town and the authority under which they act.
Well, if Mooresville can do this, where would the limit be? How, if they can require a developer to do off-site improvements 2.5 miles away, is that the outer limit, or can it be 10 miles away? I mean,
Well, I would say that to the extent there's a limit, that would be something that would be dictated by the General Assembly in giving these towns the ability to act the way they do. But when the court takes a look at this statute as a whole, 16A372 parens C, and that's discussed in Buckland, says that a town can actually ask the developer to pay to have roads improved off-site without any necessary geographical restriction on that. And some of this builds into some of the textual arguments we have about what's expressly conferred and necessarily implied. But we would look at that and say, if the within provision says that a town can require a developer to improve roads within the subdivision, and parens C says that a town can ask a developer to pay for roads to be improved outside of the subdivision, then certainly what is implied within this traffic provision, reflecting overcrowding and congestion, is that after the town commissions a TIA through an engineer, that they could enter into some kind of a private agreement, or an agreement rather, with the developer, if they could require the developer to pay for, in essence, the same work. Basically, the developer could choose to self-perform as opposed to simply paying for it. And we know that particular power is authorized under that relevant portion of the enabling statute.
under what statute can the town withhold certificates of occupancy pending completion?
Well, and so that's an interesting argument that's raised by TAC Stafford, and what they're saying, and I want to make sure I'm responsive here, but what they're saying is that the ordinance itself just simply talks about work that's done on the entire site. But that's not a complete reading of the ordinance. What the relevant section of 111 says is that if mitigation is part of an improved transportation impact analysis, all improvements for the entire site shall be implemented prior to issuance of a zoning permit, unless otherwise provided for in a phasing plan that is included in the approved TIA. And here there was a phasing plan. It's contemplated in the MMA, and then the MMA says that approvals are conditioned upon doing the work that's contemplated in the MMA. So I think to take one step back, the statute 168-372 parens A, and specifically the traffic provision, authorizes the town's actions. The ordinance itself specifically contemplates the possibility of phasing, and if there is phasing, the approvals can be conditioned upon completions of various phases of the construction, which is precisely what occurred in this particular case.
Did the developer have a choice on whether or not to enter into an MMA? If they wanted to, create that subdivision?
Well, I think to the extent everybody has a choice as to how they want to act, and I don't mean to be trite in saying that. I mean, I don't know to what degree there was give and take, to what degree there was different negotiations that took place. I don't know the answer to that, but I would offer that that's really doesn't speak to what authority that the town has to account for really the reality of the situation here, which is that there is undeniably, and I would point out, TAC Stafford does not dispute this, there's undeniably going to be an impact on the grid, on transportation, on crowding, all those types of things when you add 476 single-family homes to 200 acres. They don't dispute that. And so the town's authority to act really shouldn't be dictated so much by whether or not the developer can negotiate a MMA that they think is favorable, so much as whether the town has authority to act in the first place, which we contend that it certainly does when you look at the express language of the statute as well as what can be implied. And I guess I would just point out, just to kind of touch on these points, the expressly conferred, whether or not something is expressly conferred, the ordinance talks about its general purpose and intent to protect the public health, safety, general welfare of the citizens and landowners of Mooresville, lessen congestion in the streets, prevent overcrowding of land and undue concentration of population, facilitate adequate provision of transportation, utilities, parks, recreation, and other facilities. That's a pretty close overlap with what is permitted under that traffic provision in 168.372 parens A. So we would certainly take the position that the statute expressly confers these powers upon Mooresville to enact the ordinance and then to enforce the ordinance through the TIA and then the MMA. But to the extent there's any ambiguity or confusion about what's conferred, then the court looks at what's necessarily implied by the statute. And that same language, you're talking about promoting public health, safety, and the general welfare, sort of a broad aspirational statement, appears in 168.374 and is discussed by the Supreme Court in King versus Chapel Hill. And they say that language needs to be construed broadly and necessarily afford towns broad powers to towns, And that's really where Mooresville is operating under here. I don't want to give this too short of attention, but if the court doesn't have any other questions about the statute or the application of Buckland here, I'd like to make sure I touch on the cross appeal raised by TAC Stafford. So moving into the cross appeal, really I think we can condense the issue down this way. Mandamus is the relief that TAC Stafford sought. And mandamus is an extraordinary remedy. It's available to compel a town to do a ministerial, or government, I should say, to do a ministerial task, something that it's otherwise obligated by law to do. And when mandamus is available, there is no monetary relief that can be obtained, really subjected to exceptions. The first is that if the mandamus itself is to collect payment on a sum that's been reduced to judgment. That'd be a scenario where mandamus could result in monetary relief, or if the statute that authorizes mandamus itself permits monetary recovery. And in this case, there is a statute that does that, and that's 168.363 parens E. And the operative language there is really two terms, the term exact and the term return, saying that if the town exacted funds from a developer, it can be liable for those funds to be returned. What TAC Stafford has argued in this particular case is that return really is synonymous with recover, and that any and all funds that they can tabulate that relate to the work that they did for offsite improvements can then be recovered back against the town. But that's not what that statute contemplates. Exaction is the government taking something it shouldn't, and return is giving back what it took that it shouldn't. And in this instance, TAC Stafford paid about $101,500 to the town. They claim they've spent almost $990,000 to make these improvements. So you got $890,000 roughly that's being paid to other third parties or vendors that the town never collected and that was outside of the town's control. So at least on this aspect of the case, if in fact the trial court got it right, that Mooresville exceeded its authority, which for the reasons that we've already argued, it did not. If it did, then at least the monetary award was appropriate. And then the last thing that I want to point out really relates to the attorney's fees in this case and the determination under General Statute 621.7 that the court, or I'm sorry, that Mooresville unambiguously violated a statute or case law. Or I've got that backwards. Violated a statute or case law setting forth unambiguous limits on its authority. I want to make sure I say that right. And the entire argument for that really rests on an email from Professor Adam Lovelady from the UNC School of Government, who was asked really to comment on this situation in a vacuum. And he did. He pointed to Buckland versus Har River. He set out the facts, the analysis, and the holding, and that was really the extent of it. He wasn't provided any information about the TIA, about the MMA. He wasn't asked to consider the traffic provision of the enabling statute or to really consider any of the arguments that have been advanced here today. Now, again, we maintain that the town got this wrong. I'm sorry, the trial court got this wrong, that Mooresville did have authority to act in the way it did. But certainly, if this court finds otherwise, this is not the town violating an unambiguous limit on case law or statute, especially when we're talking about a statute that was not, a part of the statute that was not analyzed in Buckland and has otherwise not been analyzed by case law. Of course, to the extent it has, it's been interpreted broadly to provide these types of powers to towns. If the court doesn't have any questions on this aspect of the appeal, I'd certainly reserve the rest of my time. We would just ask that the trial court's order be reversed, the writ of mandamus vacated, and summary judgment directed in favor of the town.
I have a question for you. How do you reconcile 160A-372A, the provision that you've pointed out, the very end of the paragraph, with the first or the last paragraph in subsection C, which gives the alternative where developers, the town can require developers to give money to the town for the town to use and develop the roads. But looking at the statute as a whole, subsection C very clearly says it has to be within that area. So why do you think A is more broad than subsection C?
Well, Judge Wood, I believe what subsection C also contemplates is the possibility that the town would ask for roads outside of the subdivision to be improved for money for those improvements as well. So, and I think that is specifically discussed in Buckland. And so we kind of look at the statute, holistically to say there's broad grants of authority here given to the town as far as how it wants to condition development approvals that are going to impact the transportation system. And so if it's within the subdivision, you can ask the builder to self-perform the work. Paren C says if it's outside the subdivision, you can collect funds from the developer for those improvements. We would contend the traffic provision really to reconcile all of that would certainly encompass this situation, which isn't a blanket rule that they can just say you always have to pay for whatever the town asks for, but that you can do a traffic impact analysis, that you can rely on experts to give you feedback on how this is going to impact your town, and with that feedback, present those mitigation measures to a developer, and that the developer should then have the ability to self-perform that work consistent with the town's power, as opposed to just getting a bill from the town, really, to pay for the town to have somebody else to do it. We think that's the appropriate reading of the statute as a whole. That would express the legislature's apparent intent to confer this authority. Because the alternative would be a scenario where the legislature, that would almost be absurd to say you can ask them to perform work within, or you can ask them to pay for it without, but you can't ask them to do the work outside of it. There really wouldn't be any reason for that kind of a distinction to be drawn. And if anything, looking at it as a whole suggests that these powers are afforded to the town. With any other questions, I'd yield the rest of my time.
Thumbs up.
Okay, thank you.
Thank you.
May it please the court. Honorable judges of the North Carolina Court of Appeals, my name is Madeline Trilling, and I, along with my partner Jim Scarborough of Scarborough and Trilling, represent the plaintiff, appellee, and cross-appellant in this matter, TAC Stafford LLC. I'll just jump right in here with where the town left off an argument. I believe the town argued that it wouldn't make sense for there to be a provision in the statute which would allow the construction of improvements within a subdivision and the payment of fees outside of a subdivision, but not to have construction outside of a subdivision. I would argue exactly the opposite. I think it makes complete sense for the statute to read that way, and there's a number of reasons why. First and foremost being that just the situation that came up here. The town required TAC Stafford, the plaintiff, to acquire off-site right-of-way from third parties as a condition, again, in order to construct these improvements that were required. And that is really where the rub came in from a factual standpoint, because we were unable, even after offering 5-10 times the appraised value of the property, to get folks to sell the property to us. So the way the statute threads the needle is done intentionally by the General Assembly, I would submit, as based, again, on the plain language of the statute and the words that are there, and not reading anything into it that is not there. It's done that way for a reason, and that reason is to prevent a situation where off-site improvements are required and require acquisition of right-of-way from third parties who may or may not want to sell, and in this instance did not. That's a critical component, and I think generally in our statutes you see that as something that the General Assembly is aware of, and again, a private developer, TAC, doesn't have condemnation authority, so if somebody won't sell the property to them, there's nothing really that they can do, and it winds up stalling an entire development project.
So do you agree then that with the town can require a developer to pay for improvements, road improvements outside the subdivision?
The statute, I believe, is very clear on this, Your Honor, and it reads that the figures, I do agree that the town can require, in lieu of required improvements within the subdivision, the town has, as Buckland analyzed, has a choice. You can either require these improvements within the subdivision, or you can take a fee in lieu. And the fee in lieu has to be based on trips that are generated by the subdivision. So it's a very explicit formula, and in fact, even beyond that, the town has to adopt an actual formula for calculating the amount that will be attributed to the developer. So it's not this willy-nilly, and to your point, Judge Zachary, where is the line? I mean, with Buckland, the off-site improvements were abutting and adjoining the subdivision in question, but here we're talking 2.3 miles away from the subdivision. Where is the line? I mean, it could be argued the butterfly effect, I suppose, that one car in Mooresville winds up, you have to do improvements in California. There's not a clear delineation that is attributable to the subdivision if you exceed that explicit bound of being either within or trips generated and a fee in lieu.
Did your client have access to the TIA?
Yes, Judge, I'm glad you brought that up. I'm not entirely certain what you're...
I may have misread that.
I will say that my client didn't have any real option with regard to the TIA. They didn't have a choice in the consultant that was required by the town that they use. It was someone the town has an existing arrangement with, and really didn't have any say with regard to the TIA process. And just to be clear, the town sort of passes this off as part of the development approval process. This is a by right subdivision, which means that the only obligation of the developer to proceed is that they have to comply with the black and white provisions of the ordinance. So maybe a 40-foot setback requirement. It's objective things. It's, you can have residential uses in R3 zoning. Checking the boxes essentially in an administrative review to determine again, the black and white provisions of the ordinance to determine if there's compliance. It is not a situation where there is supposed to be discretion on the part of the folks that are exercising the authority to approve.
So how'd you end up with an MMA?
That's a great question. In January of 2015, we had an approved concept plan, and again, these are attached as exhibits to the complaint. We were informed by email that the concept plan was approved, and then later that same day, received another email that said, actually, we're going to have to hold on to your approved and compliant concept plan. The concept plan was obviously compliant with the ordinances, which is why it was approved. We're going to have to hang on to that until we get a TIA and an MMA in place. Clearly, coercive tactics were being employed, and in fact, the concept plan was held by the town of Mooresville for 10 months until such time as the developer would enter into an MMA. And so, again, you know, the testimony was very clear, and I believe we've cited a lot of this in our briefs, but for example, 30B6 of the town of Mooresville through Craig Culberson, who's the planning director, without the TIA and MMA, I asked him, the development couldn't get concept plan approval and couldn't proceed. And he said, right. And I said, and what's the effect of concept plan approval in the development process? And he said, it gives the developer the go-ahead to submit construction plans. And so withholding the concept plan would mean the developer didn't have the ability to submit those plans and proceed in the process of development, right? Right. And so in other words, the TIA and MMA were a condition of the concept plan approval, yes. And without them, you couldn't proceed. I mean, there's a ton of testimony in this regard that's very clear. And again, this is not an agreement between two parties at arm's length. This is a coercive tactic that is employed by the town. This is a boilerplate contract. They get to decide the terms. We can't proceed unless we agree to whatever they try to impose. This is certainly not a situation that's voluntary. And again, there's a significant documentation in the record of that. And as I said, a number of great deposition testimony chunks that really speak to that fact. So, you know, there's a great deal of case law from the appellate courts that, including, for example, Landville, the Landville case, which speaks to, you know, in that case there were voluntary mitigation agreements that were required, and the court determined that you can call them voluntary. That doesn't mean, in fact, that they are. And that's sort of what we have here. And to be clear, this MMA is not, you know, you may have seen a development agreement that's entered into in a legislative process by the town council who approves it, and it's sort of agreed to, and there's negotiation back and forth between the developer and the town. There was no negotiation that happened with regard to the MMA. This was not approved by town council. It was only signed and executed by staff, town staff, who, and again, we raised a claim as the authority of town staff to even be able to enter into such an agreement. So this is not a reimbursement agreement or an infrastructure agreement. It's not a development agreement, nothing like that. And it's called an agreement, but it is an agreement in name only. I'd like to circle back a little bit to, unless, does the court have any questions in that regard?
Okay.
Now, I'd like to discuss a few things that were mentioned about Buckland by the town. First of all, the town makes a great deal in its briefs and just now an argument about purported factual distinctions between the instant case and Buckland, yet the town fails to identify any distinction legally that these factual differences would have. So I don't know what provision of 160A, 372A that the town contends would change, but the way that Buckland reads is very clear. Buckland is unambiguous. A municipality's subdivision ordinance may require a developer to consider existing or planned streets, but the statute does not empower municipalities to require a developer to build streets or highways outside its subdivision. I'm not sure how you get more clear than that. I don't know how it can really be argued that there's a difference if there's 12 lots or 11 lots or, you know, 1 million lots. If the only factual question that is relevant is whether or not the lots are within the subdivision or outside of the subdivision. If they are outside the subdivision under Buckland, the law is clear, and again, it's unambiguous, that those off-site improvements that are being imposed as a condition of development are unlawful as a matter of law.
I think town's council would probably say that The difference is the size of this development. It's, substantially larger than the one in Buckland, and therefore likely to have much more impact. How would you respond to that argument?
I would respond again, and as the Buckland court noted, and specifically, it's interesting that the defendant claims that they would be powerless, and use that term powerless, if they're not able to require us to do offsite improvements. As Buckland noted, and as we've discussed, the town has authority to require fees in lieu. So the town, there can be a TIA which is based and determines, trips that are generated and the impacts on the system, and mitigate those impacts with fees in lieu, which again allows, as a practical matter, the developer to proceed with development of their property as they're lawfully entitled to do, and also allows the town to have funds to implement construction of road improvements that might be needed.
So why wouldn't a town do that? Rather than doing what was done here with the MMA?
That is an excellent question, Judge Zachary, and I've been trying to figure that out myself. I believe that part of the reason is because a number of reasons that may come into play. The cost of right-of-way necessary, so the acquisition of right-of-way from third parties, it's a sort of, the way that they're interpreting it, they can also push that cost onto a developer when the fees in lieu appear to me to only relate to the actual construction of improvements. So in other words, they get the right-of-way for free.
Okay.
Is what I believe, and also for political reasons. I mean, there's, folks don't really enjoy having their property condemned, even when it is necessary. And I think that, in a number of contexts I've seen, there might be political reasons that are also involved.
Thank you.
Yeah, certainly, Judge. The town also contends that there's different arguments that were made in Buckland and the instant case. I haven't seen in any of the town's briefs that there's any actual citation to any record documents or briefs of the Buckland, of the town of Har River in the Buckland case. And I'd submit that I've seen otherwise, that the argument that the town contends that Buckland made specific to the first provision or whatever of 168-372 is that's inaccurate. It's one that's mentioned in the case, but there were a number of arguments that were raised, and so I don't think that it can be boiled down to that simple statement. It just doesn't reflect the record. The town also makes a great deal out of the ordinance section 1.11, and that is actually, I point you all to a citation of that. Maybe not. It's actually on their appellant's brief at page 6 and 7. And the town contends that somehow this ordinance provides them with authority to require the offsite improvements. Well, first of all, we, as many appellate cases have determined, an ordinance that exceeds the statutory authority is invalid, ultra vires, and void. And so, and again, we've quoted cases in our briefs, including Quality Built Homes versus Town of Carthage, where the Town of Carthage enacted an ordinance which exceeded the statutory authority as determined by the courts, and it was deemed to be invalid. So even if the ordinance did provide or purport to provide such authority, that doesn't mean it can exceed the statute and the authority granted therein. But if you look at 1.11, interestingly, although the town really relies on it, and specifically in page 7 of the appellant's brief by the town, the TIA provision in the third paragraph specifically says that improvements for the entire site shall be implemented prior to XYZ development approvals. The site in the ordinance refers to the site that is being developed on site, in other words, within the property, within the subdivision, which is not only consistent with 168-372, but in and of itself does not authorize required offsite improvements. So even aside from the fact that 168-372 doesn't, as we've contended, authorize the town to require offsite improvements as a condition of various development approvals, The town's own ordinance doesn't authorize it either. And again, 168 372 provides authority for town to enact an ordinance consistent with the authorization therein, but the town would still have to enact an ordinance that said, we can require offsite improvements, we can condition development approvals on, specifically COs, for example, we can withhold concept plan approval until these, the MMA is entered into, the offsite improvements are done or what have you. So there's simply no ordinance that actually allows the town to, even its own ordinances don't allow it to impose offsite improvements based on the plain language. And in fact, as I said, are consistent with 168 372A. And Judge, you had asked, and this is an excellent point, under what statute can the town withhold COs? There's not, certainly 168 372A doesn't provide that authority, and no other statute, in fact, does. But I will note that, in fact, 168 417E expressly forbids withholding certificates of occupancy to compel completion of improvements or to compel development related to another parcel of property, completion of that development. You can't withhold a CO for Lot A to make the developer complete Lot B. And so by withholding those certificates of occupancy, the town not only was not expressly authorized under 372, but in fact, that action was expressly forbidden by 168 417E. And I have raised this issue at every juncture since the 10-page letter I sent to the town prior to this lawsuit even being filed, and at every stage along this litigation, and I have yet to hear the town respond with any sort of argument around that. And I think that's because it's pretty on the nose. I'm not really sure how you get around that. But again, to the extent that the town contends, 372A, whatever it authorizes, even then, 417E is explicit that you can't withhold certificates of occupancy. And in fact, the town isn't the authority that issues certificates of occupancy. That's a county responsibility and authority. So it is unclear, again, how the town goes about withholding a certificate of occupancy that it doesn't have authority to issue in the first place. Again, problematic and egregious expansion of the statutory authority for municipalities in North Carolina.
What action do you think they should have taken to enforce the MMA?
Judge, that's a great question. I think that there should have been a TIA done, and the TIA should have been based on trip generation, as we discussed, and Judge Wood, as you raise under 168 372C, again, there's a more explicit formula, and the TIA may be conducted, and then a fee in lieu paid, which, again, as a practical matter, would allow development to proceed and the town to have money in its coffers to provide improvements. That would have been the approach, which is A, authorized and sanctioned by statute and recognized by Buckland as an appropriate means forward, and B, that wouldn't hang up the entire process and basically essentially give third parties the ultimate approval over TAC Stafford's ability to use its land lawfully as it's authorized. And that goes to the High Rock Lake case, which was a 2012 case decided by the Supreme Court involving NCDOT, and unanimous Supreme Court said you can't give third parties the ability to determine whether or not you can proceed with development based on these offsite improvement requirements. And in that case, it was actually railroads that were refusing to allow improvements to be made to their own property, and it kept the developer from being able to proceed. And in this case, it's no different. And the court went through quite an analysis about the constitutional rights that are infringed, and why it's inappropriate to give that sort of power to someone who doesn't have any stake in the development process. And the same thing is an issue here. As I said, if they had proceeded with the fees in lieu and proceeded as allowed by statute, they would have really sidestepped the entire issue that kept this, and moreover, would have also been able to implement these improvements that the town contends are necessary.
For the fees in lieu, what's the process for setting that amount?
Under 168-372, Judge, if you, essentially, it's determined based on, I imagine the town would basically decide, do we want to require improvements within the subdivision, or do we want to go about this by getting fees in lieu from the developer? And then the town actually is supposed to adopt a formula, which I also don't know that the town has done. I don't believe the town has done, but they would adopt a formula to determine the fees in lieu amount, and they would base that on trip generation. So if there was 100 trips and the formula was 50 cents a trip, let's say, then they would pay $50 essentially as a fee in lieu. It's pretty straightforward, and again, I say that having some extensive experience at this juncture in these kind of cases, and nothing is really straightforward. But with the formula that's adopted, it's just plugging in the numbers and going from there. And again, I think the statute does that for a reason, because this isn't the juncture of the development process and the land approval process when there should be all these hangups. If you have a by right zoning for your property, and you should be able to proceed and know exactly what's going to be required of you in order to develop your property as you're lawfully entitled to do. Instead, my folks found themselves in a situation where staff was imposing $2 million of off-site improvements on them, really in a largely discretionary fashion, without having any recourse to the courts or to a board of adjustment or anything of that nature, any procedural due process really to fight against this, and that really was to their detriment, and that's another issue that arises is, and we pled a procedural due process violation in our complaint. A quasi-judicial process in hearing would be necessary, I believe, to impose these sort of obligations on an applicant in the context of development. So certainly not appropriate for an administrative context. The town has mentioned a few times, I believe it's expressly stated or necessarily implied phrase, which if it's expressed, it wouldn't be implied. I don't know how really to jive those two, but and also the 160A for broad construction mandate. I would note, and again, this is on page 10 of our reply brief, I believe, we've noted and cited Quality Built Homes, which actually cites again the Landville case, which notes that unless there is ambiguity in the statute, then the broad construction doesn't apply. And I don't think the statute is ambiguous, 168-372A. I just think it doesn't provide what the town wants it to provide. I mean, even reading, the last provision, the distribution of population and traffic provision, that doesn't say anything about, off-site improvements or conditioning improvements upon completion of off-site improvements. Conditioning approvals on completion of off-site improvements. So let me address the forms of relief that we're entitled to, and defendants' contention that the award of mandamus to TAC Stafford precludes somehow recovery of damages. These are two different types of relief that are being requested. The cases that are cited by the town that relate to mandamus, and for which the town relies on the proposition that you can have mandamus only, essentially request damages and mandamus for the same wrongdoing. Here we have two separate, and one is, I think of it like this, one's forward-looking and one's backward-looking. The forward-looking component is the mandamus relief. That is, going forward, we are entitled to proceed and to be issued development approvals by the town without regard to the off-site improvements. We have to have that component in order to be able to proceed with developing our property as we're entitled to do. The other component, the backward-looking piece, relates, again, as I mentioned, damages for the amounts that were paid and were expended by TAC in relation to the off-site improvements that were unlawfully exacted from us by the town. So $1 million later, the town says, well, there's no damages, you can only have mandamus. Meanwhile, we've acquired a bunch of right-of-way, put a bunch of improvements on them, done a bunch of engineering work, paid for TIAs and all these things that we don't need, didn't want to ever have to do, and have no need for. It wasn't to further our own efforts, and benefited the town, by having these things done. So these two components are both necessary to accord TAC full relief, and one or the other is simply inadequate to accomplish that. Again, this is not a context where we have, these two different types of relief are sought for the same wrongdoing. These are, again, a forward-looking and a backward-looking, and that's a critical point because the trial court somehow found that the remainder of our claims and damages requests were moot. And mootness is contingent upon having received the relief that's requested and no longer having a need for it in this context, and dismissed our claims with prejudice. But in reality, again, we haven't been made whole for the wrongdoing that was done. We haven't been made whole for the $1 million that we were required to expend and all this, these efforts that were undertaken pursuant to an unlawful requirement that was imposed on us as a condition of development and was not voluntary. The town says we were grown-ups and we could say, really that's not how this went down. Again, it's the epitome of coercion and inability to negotiate at any point in terms of what was going to be required of us. This is not a context, again, about as far as the remedies where you have, an election of remedies instance. I think that the trial court sort of went down that road because of the language in Buckland that says mandamus is a proper remedy to compel public officials to perform a purely ministerial duty imposed by law, and it is. That is correct. But in Buckland, there weren't any damages that the plaintiff sought to recover. There weren't any expenditures yet that had been exacted from them as a condition of development approval for off-site improvement requirements. So the Buckland, that is the one context in which the facts are actually different in Buckland, and that is relevant because here we have, again, these expenditures that were already made. Again, it's important to note, we need the mandamus also. If we just get the damages, we can't proceed with development. We're also in between a rock and a hard place. But both are critical components of according TAC Stafford full relief and are warranted TAC Stafford under the North Carolina Constitution, among other things. Just briefly to speak to the attorney's fees issue that was raised by the town. Again, this is 6-21.7. which mandates an award of attorney's fees if the court finds that there was a violation of a statute or case law setting forth unambiguous limits on its authority. The town hinges its argument on this, different clause of 160A, 372A, which, again, I haven't heard a cohesive, coherent argument on why this other provision is applicable or how that language changes the ultimate result. But, again, the language in Buckland is completely clear. There's no room for factual distinctions. There's no room for interpretation. It is, if the improvements are off-site and they are being required as a condition of development approvals, they are unlawful, and the development is entitled to proceed without those being required. So I don't think there's room for ambiguity. And again, I haven't heard the town raise a viable argument for ambiguity. And the defendant the town hasn't even offered any sort of alternative, interpretation that might create that ambiguity. So what's interesting, again, about the Professor Lovelady's interpretation that the town raised was that was the result after I sent my letter and raised the Buckland case to the town before this lawsuit was filed. The town attorney went onto a listserv and asked the question, have any of you heard of this Buckland case, and what any insight would be very welcome. And Adam Lovelady responded and said, Buckland says you can't require off-site improvements as a condition of development approval. It was clear as day, and he didn't know all the MMA circumstances and all these sort of things, but he didn't have to, because again, the question is are the improvements being required on or off-site? And so even with what Mr. Lovelady knew, he knew the answer to that question. And when the town came back to me with their response letter, which I believe is Exhibit E attached to the complaint, they didn't even mention 160A 372 at all. So not only did they not mention Buckland, they didn't mention the statute, which they now contend is the linchpin of their whole argument. That was my request in my letter, that they identify any authority that stands for any proposition with which they disagreed. So, does the court have any questions at this time?
Do you have anything?
So, thank you.
Thank you.
No, thank you.
Four points I'd like to touch on in rebuttal, and I want to start with,
Before you get going, I just had a couple.
yes,
Did the town ever consider the fees in lieu? And if they didn't, who makes that call on behalf of the town?
and I don't know the answer to that question, Judge Griffin. There's nothing in the record to that effect, and I wouldn't want to speculate as to
That's fair.
where that decision may be made. But your question is timely in the sense that I do want to start with the fees in lieu option that's available to a town. And so I'm looking at Buckland here, which quotes that relevant part of the statute. And it talks about these fees in lieu that may be used for roads which serve more than one subdivision or development within the area. And then here's the next thing that the statute says, and this gets to the idea about takings and the fact that it's more difficult for these developers to do that. It says, all funds received by the city pursuant to this paragraph shall be used only for development of roads, including designed, land acquisition, and construction. So when you read that section, it's clear that these fees in lieu, and then the statute goes on to talk about the development of some kind of a formula that would account for trips to the subdivision and things of that nature, that cost that can be passed on to the developer could include land acquisition cost. And in this particular instance with the traffic impact analysis, I wouldn't say it's necessarily doing the same thing as a formula because we don't know precisely what that formula would look like, but that's what it's accounting for. It's accounting for how are these 476 new single-family homes going to impact our infrastructure. So the better reading of this statute is not that this traffic provision that we've referred to is swallowed up and that it's nullified by the within provision talked about in Buckland. The better reading is that what the legislature did here is said, we're going to give the towns a couple different options as to how they want to account for development and strains on the infrastructure. We're going to let them require or condition approval on building of the roads within a subdivision. We're going to give them some broad authority to act for different conditions that reflect the public health, safety, and welfare without limiting their ability to require that to be self-performed roads outside of the subdivision. And if there's any lack of clarity, Subdivision C says, or we can just say that the town can ask the developer to pay for all of it, including that land acquisition. So when we look at that as a whole, that would support what the town's power in this case. And the second point, really looking at Buckland, is when the court looks at, it's either paragraph 9 of the opinion or at the pin sites 464 of this court's reporter or 501 of the Southeast Reporter, this court says, now here's the argument that the town of Har River is raising. And what they were saying was the roads that were outside of the subdivision abutted it, so that's good enough to be within. That's the argument that they raised. They did not say that in enacting their ordinance, requiring something like a TIA done in this case, they were operating under the traffic provision. I mean, every case is decided on its facts. It's decided on the arguments presented by counsel. So TAC Stafford paints with a broad brush in saying that Buckland considered these arguments or made some type of sweeping statement as to all authority for a town to act under any and all circumstances with respect to off-site improvements. It didn't. It addressed the argument before it brought by counsel. This argument is different. Looking at a statute as a whole, the outcome should be different. As far as what's authorized by the ordinance, I just want to make sure this is clear because I heard counsel reference it. 111 doesn't just say that the TIA can contemplate mitigation within the site. It does say entire site, but then it has a qualifier. It says unless otherwise provided for in a phasing plan that is included in the approved TIA. There was a phasing plan here. That's referenced in the TIA and it's referenced in the mitigation measures agreement. In fact, that's how many of this sort of came to a head, if you will, was the town said, as you get through this phase, you need to have these aspects of the MMA completed before we're going to approve the developments, which is what the MMA provides for. So the ordinance does, in fact, give the town the authority to act in precisely the manner in which it did.
And then is it your contention then that in the ordinance, the town had the authority for this ordinance from 168-372 sub C?
Well, through sub A, really, the traffic provision, because we were not operating in lieu of fees, we were instead operating to address congestion, overcrowding, things contemplated by the traffic provision. And then the last point that I want to raise just deals with the remedies here and the idea about looking forwards and looking backwards. And I cited to this court Holroyd versus Montgomery County, a case talking about damages in a mandamus action. And it says if mandamus is the proper remedy, which is again extraordinary, it's not something you can just get. It has to be unique circumstances. If it is in fact the appropriate remedy, you can't get monetary damages as well. There's any number of creative scenarios, and certainly TAC Stafford has presented one where we could say we want mandamus going forward, but looking back we have all this harm. Holroyd specifically says those delay type damages because you don't think that the government acted as quick as it should have, they're not recoverable unless you've got a specific statute that gives you the right to mandamus, which was referenced here. And again, that limits what can be obtained to the town returning what they exacted. And we contend that in this point the town acted within its statutory authority. To the extent this court disagrees, there are no further claims or further monetary causes of action available to TAC Stafford. Mandamus is the remedy, and under the statute they can get returned to them what the town took. Those are the 4 rebuttal points, unless this panel has any more questions.
I do not, thank you.
Good, thank you.
Thank you very much, Your Honors.
That concludes oral argument in this matter. I want to thank you both for your excellent arguments. We'll take this under advisement.
Thank you, Counsel.
I can go either way.
We're not taking. We'll allow Mr. Sanders to take care of